Okay, thank you very much, Anne. I won't waste much time. So today we're on about no recourse to public funds. Like I say, this is one that every week I do get a few inquiries. So hopefully people will watch this back and their questions will be answered. No recourse to public funds, right? What tends to happen is people will text and email and call to say, I'm paying tax, I've paid IHS, and I'm in a bit of a bother. I've made an application for universal credit and I've been told I have no recourse to public funds. My BRP says it, but I thought that because I'm a taxpayer and I have all these issues going on at the moment, I should have got some sort of discretion. In another way, they are right because they are paying their tax, they've paid IHS, and everybody feels when they are in a bit of a bother financially, um, they need to be attended to. Jacob has just put a question: can we ask anything else apart from no recourse to public funds? And I think we should do, because I will go through this quickly. Anyone has a question about no recourse to public funds, I'll take those quickly and then we can take your question, Jacob. Just so that we know we are done with the no recourse to public funds stuff first. Can I kindly ask that if anyone joins and they have a bit of feedback, please mute yourself. We don't want to give N that job of muting everybody and trying to find out who it is. And secondly, it kind of throws me off because I'll be thinking, is everybody else hearing me and things like that? So as soon as you come in, just mute yourself if you have any feedback in the background. So yes, Jacob, you can ask your question soon after we're done with this bit. What happens is that when you come to the UK or you're in the UK with the 2.5 visa, a lot of people call it the 2.5 visa, which is based on family life or private life, and you're on that 10-year route to settlement, which is 2.5, 2.5, 2.5, 2.5, 4 times until you get to 10 years. Then you apply for your indefinite leave to remain. Before you get your indefinite leave to remain, your 2.5 BRP, which is the biometrics residence permit, comes with a condition attached to it, which is no recourse to public funds. It is a standard condition. That same goes to people applying under the private life. Obviously, if you come as a visitor and if you're studying, it goes without saying that you also do not have recourse to public funds. But a lot of questions come from people that are going through that 10-year route under family life or under private life. And so once you're given that no recourse to public fund condition on your BRP, you start to panic. It is a standard condition that is applied to the people I've just explained, obviously by the Home Office, because they're still seen as people with temporary immigration statuses. Until they get to settlement or indefinite leave to remain, you're still seen as somebody with an immigration status that is only temporary, i.e., you only have 2.5 years. After that 2.5 years, maybe your circumstances will change and you will not be eligible for further leave to remain, for example. So it is given to people that have standard condition, that have temporary immigration statuses. And the reason for this, according to the Home Office, is to protect public funds. So we are saying that migrants or people that are coming to the UK, visiting, studying, working, and of course joining family, which is most of the people that kind of want this condition to be lifted, are subject to that no recourse to public funds conditions. We get this from the Immigration and Asylum Act, and we also get this from the Immigration Rules Paragraph 6, Immigration and Asylum Act, Section 115, if anyone is interested. So this is where all this has been taken from. When you then get to a position of settlement, this is when you can then start to apply for recourse to public funds. And of course, if you make a successful claim for asylum and you get your 5 years, you are also entitled to apply for recourse to public funds. If you're an EEA national that was in the UK by the 31st of December 2020, then you get to apply as well, because your rights were protected by the withdrawal agreement. So if you were in here before the 31st of December, or before the 31st of December, I think that's the correct terminology, then your rights would have been protected, so you can still make the claim you can still claim benefits, basically. Obviously, if you're an EEA national, you'd still need to do your pre-settlement or your settled status, but your rights are protected. EEA nationals that are entering now are also subject to this. So whatever status they're given, they could find themselves with that no recourse to public funds on there. What are public funds for the purposes of immigration? So we said we take this from Section 115 of the Immigration and Asylum Act of 1999, is amended, of course, and paragraph 6 of the immigration rules. And public funds include things like attendance allowance, carers allowance, child benefit, child tax, council tax benefit, council tax reduction, anything to do with the council, including housing benefit, or getting a house, going on the housing register, that is classified as a benefit. So all these allowances, disability, living allowance, and all those things are classified as public funds, as well as universal credit, because we know a lot of these things now have been bunched into one, which is called universal credit. So universal credit calculates what you're entitled to in terms of council, child tax, and all these things, and it's all called universal credit. So all these things have been bunched into one. So as a migrant who still has temporary you would still temporarily stay in the UK, you would still generally not be able to claim for public funds. We are excluding things like contributions-based job seekers, obviously we know that is for the first 6 months, and if you had been working in the UK, you can actually claim contributions-based job seekers, which only lasts for only 6 months, because it's based on your contribution, and then after that. And then guardian's allowance, incapacity benefit is another one that is also excluded. Maternity is excluded, retirement pension, statutory sickness pay, and the widows and bereavement benefit, those ones are excluded. The list is there. I just picked a few just to give it as examples, but the list is there on what you can actually claim. And the first place to go would obviously be the .gov website. So this is where you'd go to see what you want to claim. Is it eligible? Or you've gone to claim something and they've told you that you are not entitled. Then you can also have a look for yourself to make sure that whatever is being said. There are exceptions, like I've said, and those exceptions are there. If you want to know more about your situation, just like last week, you can email me and then I can have a further look for you. But today I'm not going to say I'll do it between Monday and Tuesday, because last week I've had to email some people to say, bear with me a few more days. I'm still responding to those emails. So within this week, I'll be able to email you. And then if you want to have a conversation, we can also have a conversation about that. So those are the benefits. So what happens then if you have no recourse to public funds and you feel that at this point, coming out of COVID, for example, and a lot of people were actually asking during COVID times whether they could claim. And the answer is yes, you can make an application to get that condition of no recourse to public funds actually changed. You can't just fight with a body, for example, with the council or with universal credit people, and just be fighting, oh yes, I don't have money, this is what's going on. You would need to change the conditions first by filling in a form. Nowadays it's done online, and it's called a change of condition forms. It carries a fee. You put in that application online, and then you pay your fees and you wait for the Home Office to respond to you. If, for example, you have, let's say, 2 years left on your visa, the no recourse to public funds will come back with that the time that you have left on your visa. So maybe you've sent it, and then after they send you back when you're left with 1 year, 10 months, it will come back with now you have recourse to public funds for that 1 year, 10 months. Can you please mute yourself, please? Somebody is talking in the background. So when it comes back to you, it'll come back with recourse to public funds, but it will be for that time until your 2.5 is finished. So when you then make another application, that no recourse to public funds can then be imposed once again, unless you tell them that you are destitute. If that's indeed is the case, then they can look into that, into putting it. So what I wanted to say here is that the no recourse to public funds, every time that you make an extension application, then you would need to also ask for the conditions to be changed, because the conditions, like we said from beginning, they are standard conditions that come with these types of visas anyway. So you would need to still show the Home Office that, okay, I am still in that condition, or I'm actually worse off than that time you gave me that recourse to public funds. And the recourse to public funds only applies to the time that you have left on your visa. So if you apply, you get your 2.5, and then within a month something changes, and then they respond to you after maybe, when you're left with 2 years, it'll come with only that 2 years time. And then after that, you'd have to. So you'd have to do the application again, the change of conditions application. The reason being, they always think that your sponsor or somebody that supported, let's say it's your partner that supported your family visa, they declared and they showed the Home Office that they are going to be able to look after you. So something has changed, and you have put in that something has changed. They've agreed to that at that point, but they still go back to the fact that you had a sponsor. So you would still need every time to show that, okay, this is what has happened. And it goes without saying that if you claim benefits when you have no recourse to public funds, according to the law, it is actually a crime. It can actually hinder your extension visas, or when you get to your time of indefinite leave to remain or naturalization, it can be something that will flag up, and it hinders your chances of your extension or your indefinite or your naturalization. So if you know that you really need to make the claim for benefits, then change your conditions first using the form. Like I said, the forms are so easy now. They are online, so you can do it online, change it, and then just do everything legally and legitimately, rather than going to claim benefits and then they come back for their money, number one. And secondly, it is a criminal offense that actually you might actually get some criminal based criminal type of punishment, which obviously will affect your DBS, and it will affect your further applications to the Home Office. So we're going to move on to, at what point can I claim recourse to public funds? And it's just simple. When you are a destitute or you are in immediate risk of destitution, you can claim, you can make the application for change of conditions so that you can claim public funds, so that maybe you can go and freely claim to be on the housing register, for example. You can freely claim universal credit, for example. Destitution is when you don't have anywhere to stay, or you are at risk of immediate risk of maybe eviction or not having somewhere to stay. This usually happens sometimes where somebody has lost their partner, maybe their partner has passed on, or their partner is actually not able to work, and they have a disability, and there has been a change in the family home, and that person now is working, but let's say they still have a lot of bills and also children to look after. They can make that application to say, well, maybe I'm widowed now, and I've got these children, and I'm still trying to find my footing in terms of looking after the kids and maybe moving on with life post the passing of a loved one. So that's one of the situations where there's extenuating circumstances that have made you to apply for recourse to public funds. Destitution or any immediate risk of destitution, definitely you can change your conditions to recourse to public funds, and then you can now access the benefits. Inhumane or degrading treatment. If you're suffering inhumane or degrading treatment, you can also make an application of change of conditions from no recourse to public funds to recourse to public funds. What is inhumane or degrading treatment? Probably where you are living, where you can afford at that time, is costing you a lot of money, but the landlord is not fixing things like mold, the taps are running, the house has no heating, all these things that make your living inhumane, or that makes your living degrading. Degrading, we're talking about homelessness, of course, if you're out on the street, but also inhumane treatment. Whilst you're still trying to sort out yourself with the landlord, maybe he's not responding and all these things have happened, and you're trying to sort out yourself with them. In the meantime, you'll probably have seen that maybe council properties are available in your area and they're cheaper. You can make the application, because if you go straight to the council, there's a chance they'll tell you that, well, we can't help you because you have no recourse to public funds. So you'd have to change this first to a different condition. And then after that, you can then change, you can then access the recourse to public funds. So destitution or immediate risk of destitution, inhumane and degrading treatment. If you're suffering inhumane treatment or degrading treatment, family circumstances have changed. We talked about bereavement. There's also issues of difficult pregnancies. When you have a difficult pregnancy and your other partner maybe is on disability allowance, they are disabled, they are not able to work. So you were the one that was actually working, maybe with an agency, and you exhaust your benefits in terms of the agency side, in terms of your pregnancy benefits that you are meant to exhaust, and you have nothing left, and you find yourself maybe with a child, a disabled partner, you can make this claim. Of course, if your house's income has significantly dropped as well, to an amount that is very low because of some change of circumstances, somebody was on part-time work, temporary, and there are no jobs at the moment, they're still struggling to find work, things like that, then you can also make this application. But you need to have the evidence to show them, and you also need to be able to present your case well for the caseworker to actually understand what you're talking about. Them changing from no recourse to public funds to public funds is a discretionary type of thing. It is not an entitlement. It's based on their discretion. So you have to be able to have, one, your evidence to show and say exactly what you want to say to them. And secondly, be able to articulate what is going on in your household very well. This might even include letters from the partner that you're living with, maybe that used to be the main breadwinner. It might include your hospital letters if it's cases of a difficult pregnancy and maybe you were on a month-to-month contract. You can attach stuff from your midwife, from your hospital. to say that in terms of incapacity, obviously you can attach all the paperwork when it comes to that. So that's what you would have to do. You can't just jump saying my personal circumstances are really bad. Then you jump from there to going to fight universal credit people. It doesn't work that way. We do get a lot of people saying, they're saying, I don't qualify for universal credit, but this has happened to me, this has happened to me, this has happened to me. Unfortunately, you would have to change your conditions first using that form. And then after you've done that, you can then make the claim with a free mind anyway, but also knowing you're doing things according to the law. So that's in a nutshell when it comes to no recourse to public funds. The application is done online, like I said, and you can attach all your documents and all your supporting statements in terms of your supporting letters, anything online as well, according to the new system. So I'm going to ask if anybody has got a question, because I think I've kind of talked for a long time. So anyone that has a question with regards to no recourse to public funds.
How easy is it for somebody to get these benefits or financial assistance, really? Is it?
In terms of after they've made the application or the application itself, or after? After
they've made the application.
Okay, after they've made the application, they are actually entitled to claim it, to claim the benefits. So if they're now, if the Home Office now agrees that they can have recourse to public funds, maybe for 2 years after they have they've exhausted their visa, maybe just for half a year, then they should by all means be able to claim. Nobody can say no because the government has given them the okay. Of course, there are some organizations, by organizations we mean the public sector. Some of them don't really understand. So when they see maybe 2 years on your visa and then it says recourse to public funds, they think maybe it's not a genuine document. So they would have to make checks. They'll start to say, okay, I need to check this with the Home Office, make sure really you have recourse to public funds, because this application has actually been made, has been brought to the limelight by COVID. Prior to COVID, a lot of migrants didn't know they can actually make an application of change of conditions, which meant wherever they're going, people still didn't know. So some organizations are still catching on. So they would question here and there, but according to the law itself, there is no reason why the person cannot make any type of claim, be it housing benefit, council reduction, put themselves on the housing register, universal credit, child tax, all the benefits that they are entitled to, they should be able to. It's a case of maybe if the person doesn't know, educating them and allowing them that little bit of time to actually, check what they need to check, because sometimes they wouldn't really know.
Thank you. Thank you.
That's okay. Anyone else with a question on this? Is this for people with stay or no stay? Someone has asked a question. No recourse to public funds is for people with further leave to remain or with leave to remain. That is usually 2.5 years. We are obviously saying students and visitors and them are excluded. I think everybody will know that. But we're talking about people that maybe have made an application under the private life, and they got 2.5 years under private life, under the immigration rules, under the private life situation. They've been in the UK for 20 years and more, and they are now claiming a private life, and that has been granted. They've got their 2.5 years. It will come with no recourse to public funds. family life as well, when somebody's made an application basing on a child that has been in the UK for at least 7 years of their life, and maybe they didn't have a stay, and now the child now has a stay of 2.5, and the parent, because they are the legal guardian of that child, also then get 2.5 years as the parent of a child, or a parent of a child who's actually a British national. So maybe the child has got British nationality via one of the parents who was settled at time of birth of that child, or the parent was a British national at time of birth, then the child becomes a British national, and then the other parent then gets on to the to that applies under the parent of a child who is British or has been in the UK for at least 7 years or more, and they get the 2.5 years. Those types of people cannot apply. Partners as well that have entered the UK as a partner or are in the UK but managed to get on the partner route and they get their 2.5 years, they are on the 10-year route to settlement, cannot apply for no recourse cannot get the recourse to public funds. So they would need to make the application of change of conditions. And then after they've been given the permission to, then they can start to apply for benefits. So I hope that answers your question. Somebody that had put something there. And then someone said that, okay, yeah, it's a direct message. So hi, is this for people with stay or no stay? So I hope that answers that. If you don't have a stay, it goes without saying you have no recourse to public funds anyway. You have to sort out your immigration status. And at some point, it might come with no recourse to public funds. And then you'd have to change it, ask for change in conditions. Then the same person who's direct messaging is saying, can you apply if you have an application? Just bear with me. Can you apply if you have an application with Home Office as asylum or mother of a British child? I think mother of a British child, we've already said you would have to apply for change of conditions. If you're on asylum, you're already getting NAS, so you don't apply for a change of conditions because you're on a different route to settlement. You've made a claim for asylum, you're running away from something from your home country. So NAS, asylum have a slightly different procedure or process. So you would apply for further help in terms of your upkeep and things like that through NAS, and they'll be able to help you with what it is that you're entitled to. So I hope that answers your question, direct messenger. And this one says, those if affect future application to settlement for parents. Okay, I think he's trying to say, will it affect future applications for parents? But I'm not quite sure if that's what you mean. If you've made a recourse for, let me see what you have said here, application to settlement for parents. Okay, so if you change your conditions at some point, and you actually get your recourse to public funds, when you get to the settlement stage, it shouldn't affect you getting your settlement because the Home Office have agreed to what you have said to them, that at some point you were going through a certain level of hardship and you needed that help at some point. So you don't have to keep on applying to change of conditions every time you get your 2.5 years. It could be at some point things are hard, and then when you renew after that, you are now okay. You can still make a basic general application to extend your leave, or what we call further leave to remain, and it will still come back with no recourse to public funds, and you're okay with that, you're happy with that, then that should be okay. It does not affect settlement because you, at some point, they agreed that you were going through, maybe you were destitute, or maybe the example I gave of a difficult pregnancy, and maybe the other parent is on incapacity or things like that, bereavement, and it was left to you, maybe you were on part-time work or zero contract hours and things like that. So depending on your circumstances, and they've allowed you to actually change from no recourse to recourse, then that shouldn't apply your settlement when it's time to settle. Another question here says that, can someone get benefit through Zombrano visa as a single mother? And the short answer of this is because that is under the EU conditions. When we're talking about that, I think it's a case of when you actually made this application. But what I would say to you, please send me an email and then I can take you through, because there's actually a whole lot more I would want to understand it, in terms with regards to your question. So if you email me, then I'll be able to explore this a bit more with you during the week. Okay. Does anyone else have any more questions with regards to recourse to public funds or no recourse to public funds? Okay, if not, because we still have a bit of time, I will take any other general questions. If I'm able to answer them, then I will answer them straight away. If it's something that we will need to chat over emails and things, I'll say so. Any other questions in general in terms of anything that has to do with immigration?
Yeah, I think Jacob has his hand up.
Okay, Jacob, you can ask your question, please.
Thank you. Good evening.
Good evening.
Yeah. I just want to ask this question. There is a new changes to recently. There's a changes to immigration rule recently for a child born in the UK who has clocked 7 years, and if they put in application for the child, is going to, the application will go straight to settlement. And I want to know if the family of the child, the parent and the siblings, can go in the same time with the child.
Okay, you're saying that the child has been in the UK for 7 years.
Yes.
Okay, and you want to know whether everyone can apply under the child.
Yes.
Based on the child's right to stay in the UK. Okay, well, the short answer is yes. I would recommend that with the application, maybe you do it with the one parent, and then once the application has been done, it's successful, then you can then make further applications for the rest of the family, including other family. When you make that application, they will ask if there are any other family members that are in the UK that are not applying, and the answer will be yes. And then you list all of them, the family members and stuff. And then when that one has come back, anyway, this is how we do it, is we do it one parent with the child. And then when that one has come back, then the rest of the family can then be added on, creating the family unit, talking about them as being a family unit, that they have always been together in the UK, that has not been disintegrated, and now one parent and one child have lived to remain. Then you add everybody else, because obviously it can become overwhelming for everyone in terms of, number one, finances, and secondly, just your arguments. Unless obviously you're using a lawyer, then that should be fine.
But if the child, if all the family, they are under the children trust, and the government has already aware that all the family are living together, Is it not possible to go in the same time, or that's the best way to do it?
Okay, like I said, you can do it at the same time. There's nothing wrong with that. I was just saying that sometimes it's easier and quicker to do it with the parent and the child first, as the parent of the child. Of course, the form will ask whether the other parents, the other parent, where are they, and other siblings, and where are they, and you put it in. But for example, if you're doing it yourself, just to make sure that you get it right, and also to make sure that you stagger your finances, you can start with the child and one of the parents, and then you can put the rest of the family on. But nothing stops you from doing it all at once, depending on how many other people are there. Then you can, as long as your financial strength is fine, and as long as you'll be able to make all the necessary arguments, then that shouldn't be a problem.
Okay, thank you.
No problem. Somebody has sent a message. Do children born in the UK and have parents did not have permanent residence? So I'm assuming the children did not have permanent residence, or the parents did not have permanent residence. The children are now 18 and 16. What are their rights now? The parents are struggling with money. Can you help with such a scenario? Right. I'm not sure who didn't have permanent residence here, either the children or the parents.
It's me who posted that the parents didn't have permanent residency when the children were born.
Okay.
And now the eldest is finishing 6th form. And the unis they've been applying student finance is starting to ask, what is your legal status is in terms of residency? And the children don't have anything apart from
okay, so they actually don't have any leave to remain at all, not even any 2 years or anything. Now Nothing. They want to start to regularize their stay.
Yes.
All right, for the one that is 16, if, like you said, they are born here, they can apply for that nationality application for somebody that was born in the UK and they've used the first 10 years of their life, or they've lived the first 10 years of their life in the UK. The first 10 years being the formative years, where a child learns their identity, their language, where they identify as home. So they now identify as British, and they now look at England as their home. So the one who's 16 can actually take advantage of that application, apply to naturalize, to be registered as a British national, and then they can get, because they were born in the UK and they've spent the first 10 years of their lives in the UK. Once they're registered as a British national, then they don't have any issues. The one who's 18 is now classified or seen as an adult. However, this child has spent all their life in the UK, so they would have to go under immigration rules, private life of somebody that has been in the UK all their life, and they know nothing. There's a section that says if you have been in the UK for at least half of your your age. So they have been in the UK for 18 years, so they can utilize the private life provision, because unfortunately they are now over 18. So naturalizing straight away might become a problem, because then if they want to make an application to naturalize, they need to invoke the discretion of the Secretary of State saying I was born in the UK, and put all those evidences. It's not something that is not doable. It's doable, but they need to show that now that I'm an adult, but I was born in the UK, and I would like to be naturalized as such. However, the immigration rules also will give them a redress or something they can apply for, which is 2.5 years, as somebody that was born in the UK and they've been here for 18 years. So they would be on that 2.5 year visa at least they would be able to get their leave to remain that way. Naturalizing as such, they'll need to write the English test, life in the UK, but also it is based on the discretion of the Secretary of State. So there will be a chance that they might not be able to actually get to naturalize as British. The 16-year-old will be able to do so because they're still underage, they are a child, and they have been in the UK for at least 10 years of their lives. The parents also, depending on when they've come, because if they have a child that was born in the UK, that has been here, that was born in the UK, and the child is 18, chances are they have been here for 20 years or more, right? Or maybe slightly under. They can also try and make an application under the private life, being in the UK for 20 years and now invoking their private life. Or if it's under, then they would need to come up with extenuating circumstances of under 20 years and why they cannot return to the country of origin. But I think your question was mainly asking for the children, right? I just touched on the
yes.
briefly. Yeah. Okay. Can a student that have stayed and live in the UK for 2 years and sorry, it's gone off. This is a direct message. Can a student that have stayed and live in the UK for 2 years and she have a daughter 18 months, can she apply for private life visa or family visa? I'm not understanding. So I'm assuming the daughter doesn't have any stay, i.e. the other parent is not a British national or is not settled, so the child doesn't have any leave to remain at the moment. The short answer of it is when you are a student, you have said you're coming here to study and you're going back. So moving from a student visa to another application is always very difficult because the Home Office wants you to actually go back and then make any other application. So let's say your husband is now a British national, for example, or your husband is now settled and you want to apply for partner's visa, or your child is nationality or is settled. The reason is students usually, or obviously on their applications, they say that they're coming here to study and they will be going back. So when you want to move from a student visa to something else, you have to first go back to your country of origin and then make that application from back home to here. There is an exception to any application that has to do with this type of family life involved. If your other person is British or is settled and there are extenuating circumstances why you are not able to go back and come back under their sponsorship, because that person becomes mainly your sponsor. So it depends with what's going on in your personal circumstances. Is that person working? Are they, are they capable? What is their mental state, physical state? What role are you playing in that person's life that actually stops you from going back home to make another application to come back here? Merely having a child in the UK does not automatically grant you any type of status, even if you have the British birth certificate. What is important when you have a child in the UK that is British is the passport, obviously. But if your child is not British and they only have a birth certificate, then that does not really mean that you can then make a further leave to remain application based on the child and all those things. So I hope that answers your question, because there's a few variables there that I didn't know. I just assumed that this child is maybe doesn't have leave to remain because you gave birth to them whilst you were here, but your child is not a British national. Okay, any more questions for me?
For those who've just joined, you can ask Anya any immigration related questions. and she's here to help you answer. So take advantage, please.
Hello.
Hello.
Hi. I just want to make I just want to ask a question. If you have a British child and you want to make an application, and they're asking to apply through private life, private family, or private visa, so I don't understand that. Please, can you enlighten?
Okay, if your child is British and you want to apply under family life, the application is called the private and family life. The form comes as such written that, but you are mainly going on family life because you have a family member who's a British national, who's your child, and you probably are either the sole carer, as in you're the only one that really looks after the child, or you have you look after the child with your ex-partner, for example, but maybe the child lives with you more and things like that. There's an agreement, either just a social agreement as parents that he sees the child as well and you live with the child, or vice versa, he lives with the child and you see the child, or there's actually a court order to say your ex will see the child at this time and that time and that time, and you see the child who has that right to live with the child in terms of a residence order and things. So whether there's a formal or informal agreement, as long as the child is a British national, then you make an application under the family life route. The application form is FLRFP, which is the further leave to remain on family life or private life. So I think that's why you were confused saying they're saying private or family life, but you are mainly dependent on the family life and your child is your family. You would make this application. Nowadays it's done online. So you make the application online, pay online, book your date to go and get all your biometrics taken online. You can upload all your supporting documents online. The main supporting documents you need to upload on there is the birth certificate, the passport of the child, obviously your documents as in your passport and things, and all the supporting evidence to show that you are co-parenting with this other person who is a British national or who's settled in the UK, therefore cannot return to your country of origin with you just for the sake of accessing their child's right. Everything centers on the child. It's under Section 55, which is the best interest of the child. So the Home Office are looking at what is in the best interest of the child. Okay, it's in the best interest of a child to have a relationship with the mother and a relationship with the father. Now the father is a British national, or the father is settled in the UK, or the father has asylum, cannot travel back to this person's original country just to access their rights of this child. So it might be better for the mother to stay here so that the child can have the best of both worlds, which is the mother and the father, and therefore they'll give you 2.5 years as a parent of a British national, where the other parent is not part of the family unit. So I hope that answers your question. Okay, any other questions before?
Yes, I have a question.
Okay.
Hello? Yeah, sorry, I just joined in, so I don't know how much is been discussed. But my question is, I've been in UK for about 17 years now, or 18. I've got 3 kids. 2 of them are British because they were born in this country. The last one is 9, and he'll be 10 by August. So, which makes him to have his own British passport as well. But my problem now is I've been wanting to go to school in this country, but it's been
Sorry,
a
I
very
didn't quite catch that. Sorry to cut you short. You said your question is?
Yeah, I want to go to school, to be able to school here.
You want to be able to go to school? Okay.
Yes, but because the documents we have, immigration status is no recourse with to public funds. So on a 10 years route, which is bound to expire end of October this year. But the thing is, I've applied to study to do nursing in school. So I was given admission in Northampton Uni last year, but because of this issue of no recourse to public funds, the student finance, they were unable to grant me the the fee, the loan for the study. So this year again, I've applied again and went for interview. Fortunately, I was given admission again to study to go in September this year. But unknown to me because I was thinking permit by August they would clock the 10 years, which will allow us to have indefinite leave to remain or settlement. So based till October. So my problem now is how would I be able to go to school? Because knowing fully the students finance, they wouldn't be able to approve it. I don't know because the age is no longer on my side as well. So I don't know if is there any chance for me going in, or I don't even mind if they will mean me paying maybe the first year. So I don't know how it works.
Okay, so student finance will not give you finance when you have no recourse to public funds. So you will keep on getting admissions because you're obviously competent for the course. So the uni wants you, but your problem is you're asking the government to pay for your school fees and then you're going to pay them later, but you're not settled yet. So what you're asking them is something that they can only do for people that are settled. So you getting admission is not the problem. It's brilliant because you're definitely competent to do the course. But the government are the ones saying, well, we can't give you money now because you are not settled. So you'd have to wait until you get your indefinite leave to remain. Otherwise, you keep on applying, they'll keep on saying yes, and you keep on getting frustrated. Another alternative, obviously, would be to pay your fees. So if you were paying them privately as a person, then the uni will take you and then you pay. And then when you get your indefinite leave to remain as from next year, maybe, then you can apply for student finance for year number 2. And then when year number 2 finishes, you apply for student finance again for year number 3. So unfortunately, it's a bit of bad news there, but you'd need to get settled first before you can apply for student finance.
Okay, that's clear. Thank you.
Okay, that's fine. Okay, all right. There's nothing on the chat. So I will take maybe one more question if anybody has a question, and then we'll put the session to end. If a question pops up later, my email address has been put on there by Anne. Just drop me an email and I'll respond to your email. And I think there was one person that I said email me so that we can have a further chat. Then I will also respond to that as well.
Hi, I just want to ask a question. Someone has a preset to which is 5 days, and in that BRC.
Oh, apologies, Olivia. I can't hear. There was a bit of a feedback. Do you mind starting again?
Someone has a presettled, which is 5 years, and it was written on that BRC card that you can work and you can study. So, and they make an application with college, and the college said because he was in this country for the past 10 years, he doesn't have any entitlement. He have to pay almost 3,000 grand before he can study further or something.
The college say they were not in this country for sorry. So the person has pre-settled status, then EU national. Is that what you're saying? Okay. I think if I heard correctly, she's saying that the person has pre-settled status and then they went to apply to a college, and the college is saying that they will need to pay because maybe they are looking at them as an overseas student. Then this becomes an issue of the time they have been in the UK. It becomes an issue of the residency requirement. Have they been in the UK for long enough for them to qualify to get student finance? So student finance have their own residency requirement. And if you can't show that, excuse me, that you have been in the UK, I think for at least 3 years, they will not actually finance you. So maybe that's the reason why the college then said, we will take you on, but as an overseas student, and you have to pay the money that the uni wants you to, the college wants you to pay as an overseas student. So I think that would have been the issue there, that they didn't qualify for finance because of residency. They've not been in the UK for long enough. Student finance will look at whether you have recourse to public funds, but they also look at, have you been in the UK for long enough before they can give you the finance. I hope that answers the question.
Yeah, I think we've all the questions have been answered. Ladies and gents, this is Immigration Project. Zoom sessions on the weekends, Saturday evening or Sunday evening, and it aims to answer the questions, the most asked questions on immigration. We're going to have different topics. This is the second week. The first week, last week, was about the health and social care visa. So people who are already in this country, or people from Africa mainly, can come to this country to work, and what the process was. And Anya kindly led that session as well. Obviously, this one has been on no recourse to public funds. We'll probably run the session again because I think a lot of people missed it, maybe because, as Anya said, it's a Sunday evening, but it is something that we as a charity get asked a lot, really. So we're going to try and get the Zoom session out again one Saturday evening. I think that our next session is going to be on frequently asked questions, on questions and answers. So as Anya was giving answers this evening, the next session, which might be next Saturday or Sunday, if you keep an eye out on the WhatsApp statuses, we will be publicizing that. So you can come with your questions, prepare them beforehand. You can, I think many of you know my phone number. I'll put it on here as well. And you can always send me, text me with the questions, which we can then compile for Anya. But I think this evening session is about to end, and thank you so much for everyone for attending, and we hope it has been useful. Anya, if you want to say something, and then we'll.
I just wanted to say thank you everyone for coming, and if you got something that you think will help somebody, please do let the person know that you've got this. The idea for this sessions, just to give a bit more information to the public, something that obviously people would pay a lot in consultation fees and then one-on-one session, consultations, but we just want to support our community and make sure that people are informed, especially when it comes to immigration matters. So just make sure that if you got something that somebody might benefit from, do let them know that, okay, this is what I had today. And yeah, we just help each other one person at a time. Thank you to everybody that is putting comments saying thank you, Anya, and staff, thank you too for coming, and also for your time this evening. I really appreciate it as well. Thank you very much to UAA for doing this. I think this is brilliant. I really love what Anne and your team are doing. This is absolutely good because we'll be able to reach out to our community in the masses rather than on a one-to-one basis. So thank you, everybody.
Thank you.
Thank you. Yeah, there is a YouTube. I've put the YouTube link. We're going to be uploading it hopefully this evening, so you can then kind of watch it, share with your friends and anybody else, and then join us again next week for another Zoom session on immigration. Thank you. Thanks.
Okay. Bye, everyone. Bye.
Bye.